You're so focused on the end goal of finally getting property settlement that sometimes you forget that there's a bit in between separation and final orders. Today, we're going to be talking about what happens to your income, your expenses, and your savings when you're going through divorce. Welcome, Mum.
Hello, Laura. Hi, everyone.
Now, this is an episode I wish I'd had myself going through divorce because it is
Oh,
literally the last thing you think about when you're going and looking at your assets and the house and whatever else you've got. The last thing you're thinking about is what you're spending your money on during the separation and just the stuff that happens in between. And
yeah.
let's get to the big one that people really miss, Mum. But first, we're going to go to our jingle.
Hello, I'm Laura Furiosi, divorced mother of three, and I'm here with my mother, Lynette Galvin, with 35 years' experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom.
Now, it's important to note that this is for Australian people. This is for the Family Court of Australia. This is the Family Law Act information. Always go and see a lawyer as each individual situation is different. This is just a general discussion about the education around this kind of topic so that you're aware that you need to figure out what's going on with your situation. So, Mum, let's talk about savings first. Welcome, by the way.
Yes. Thank you. That's a very sore point, isn't it? Savings for people.
Yes.
Because I guess when you get out of the situation, first thing you want to do is make sure you're going to have enough money so if you can possibly manage it, you're squirreling away
That's right.
to little bits and pieces.
Yeah, well, that's right. The first thing a lot of particularly women do when they come out of situations and if they are controlling or financially abusive and they've finally got money to themselves to decide what to do with in any situation. I know a lot of our members and listeners, they start saving. They want to create a nest egg for themselves, even though they haven't got to the end goal. They're not at property settlement yet. They want to start being independent and doing the right thing with their money. But the catch with that is, Mum, like if someone is saving and they haven't had final property settlement yet, what everybody needs to know in Australia?
Yeah. Everyone needs to know that the money that you saved is part of the property settlement and it gets divided between you both as an asset of the relationship. So it might be that because you made the contributions to it that you get a little bit higher percentage of the overall property. But yes, what I think I worry about is people who think it's not part of the property pool.
I don't want any of our listeners, any of our members to get to final mediation or final trial and find out that they've got to put their hard scraped earned savings into the property pool. So, Mum, then that comes to I guess the income and expenses section. So let's talk about expenses. And I know a lot of these people, they saved up this little nest egg through lowering their expenses by maybe not buying brand new school shoes, going to a secondhand store, maybe not getting the new stuff and just holding back on things that they need, but holding back. And that expense, those expenses, when you look at it from the point of view of the person who is saving and trying not to spend too much, what do they need to know? What are the rules around expenses?
Yes, well, expenses apply. Expenses are of interest to the court in the property process, where the money that's being spent on these expenses at the time of separation. So if you had $40,000 each, say you split it up and you came away with $40,000, unless you can show that you've spent it on reasonable things like this kids' school shoes and so forth, and normal living expenses, the court may well add that back into the property pool.
So can I just ask a hypothetical question then? So imagine they're separated and they're like, let's just split what we've got in the bank account for now. We've got 20 grand, so I'll give you 10, you have 10, and then they go their merry way. And then at some point they come to property settlement a year down the track and one person has saved that 10,000, maybe it's now 15,000, and the other person has spent it all.
Yes, has
What
zero.
happened? What's the situation there?
Well, the the suggestion is if that's been spent, that would be an add back usually into the property pool. Each of you had your amount of money. We'll put it back. You've still got yours in the bank. We'll put yours back as a notional add back, the fellow or person who has spent all the money and got zero left in the bank. But that person with the zero left in the bank can argue against having that whole lump sum put back into the property pool and then treated as part of their property settlement. Is that making sense?
So basically, the person who saved the money, it has to go back in.
Yes.
But the other person who didn't save the money, if they can prove that they spent it on reasonable living expenses, then it doesn't have to go back in.
That's right. It might be some of it is reasonable living expenses and the rest is not reasonable, like buying a new car or whatever, overseas holiday. And it's often the financially weaker person who gets their share and they have to spend it. But they just can't not spend it because they need it to live on, or they might be using it for legal fees.
So what everyone listening today needs to understand is that the money that you have and the money that you use and the money that you spend between separation and final property settlement, whether that's 2 years, 5 years, 1 year, 6 months, is going to be looked at. And I have heard stories where they've gone to mediation, they've done disclosure, and their ex has their bank account say $0. I have $0. And their bank account, has for $10,000. So you're saying the argument is they could say it's reasonable living expenses.
Yeah.
What can the person do who's like, well, that's just obviously BS. They've just squirreled it all away, or they've spent it all.
They've hidden it or something.
Girlfriend or something.
Yes. So the person who says, oh, but my expenditure was on reasonable living expenses, the onus is on them to prove that it was. Otherwise, the default position is, mate, you've had 20 grand, mate, you've had 20 grand. That's part of your property distribution.
Okay.
So the onus is on them to make that proof.
There are people who write in who have said to us this add back thing, because we've done an episode on help my ex is spending all the money. So we are going to move into some other things as well. But they've written, add backs don't really happen. No one really lets that happen. So have you seen add backs happen? Have you seen where they say you spent that money on a holiday overseas, you need to put that money back in the property pool? You've seen that happen?
Yes. Oh, yes. I read a case only yesterday, where the judge said about someone's credit card debt was factored in as a loss, debt of the parties. And he just said, no one's given any explanation why a post-separation debt is being added into the property pool, so I've taken it out.
Right.
So they are starting to be clear. What I think happens, Laura, is that the lawyers themselves are low in confidence sometimes, and they go, oh, no, don't worry about add backs, because, they are hard to prove. But you've just got to look at those cases of Weir and Townsend. It works. But it's never been codified. It's not written out in the legislation. It's just by a lot of cases. But there are a lot of cases about it. So if your add backs didn't work, either the lawyer wasn't trying or your case wasn't one where it should have been add backs. I mean, we always have to argue the add backs. No one just automatically agrees to it.
Right. So Mum's mentioned the case of Weir and the Townsend case. If you're interested in that, you can go and listen to our Patreon videos where Mum describes that case and explains how it all works. So you can go and listen to that if you're interested on Patreon, the divorce course. So Mum, you mentioned basically that you have to be proactive about this. So
yes,
you have to be proactively saying, well, that needs to be an add back. But we got this email only recently where the ex had tallied up how much it was now costing him to support his new girlfriend and then her child, not his child, but her child. And it was going to cost this much a month or whatever. And he'd been spending that much money on that person out of the matrimonial things. The ex was arguing that he needs that money. He can't afford to pay her, what she was asking because of that. But you were saying what?
I was saying you don't get to prioritise another family over the family you've just left, and in particular when it's not your child and it's another adult, because the court is dealing with this relationship. But also this sort of issue was resolved very early on in the Family Court and Family Law Act's life. And the court has always been quite adamant that if someone gets a share of the property pool and spends it on something, whatever it is, that's fine, they can do that. But the court will still look at the 20 and not the extra expense. And then when they try to put in about future needs, oh, I've got to support this person. No, Section 75(2) of the Act says it's only an adult who you have a legal obligation to support.
Right.
All right.
Right.
And it doesn't include step-parents or stepchildren. And that's been very clearly decided also in the child support legislation. So whatever that person's done with his money, fine, but the court's going to look at what he got and he can spend it on whatever he likes. And that's how the court does look at those sort of things. They're very minded about what you get and what you do with it.
What about holidays? We get a lot of people write into us about holidays. So they say, my ex, we've separated, he's disappeared or she's disappeared for the last 2 months on a holiday in Bali, and I've got no way to stop them from spending our savings, and I can just see the bank draining out. What about holidays?
I think that comes under the same category as any other radical expense. If it's come out of, and the court makes a clear division here, if it's come out of matrimonial money, like money from the relationship, from during the relationship, then the court will say, that's fine, you've spent that money, but it still goes in as a nominal asset on your side of the ledger. So you might have been going to get $100,000 property settlement, but because you went to Bali and you blew the first 20 that you had, well, you're only going to get 80 now. And the 20 will say, you've had that and you've spent it. Whereas your nana used to say, we've had tea and I've washed up if you went out to the kitchen for any more food. But there's a difference, though, between spending money that was in the marriage or available to the parties during the relationship and spending your wages.
Yes, and we're going to get into that in a minute.
Oh, okay, you're aware.
We're going to get into the income and wages in a minute.
Yes.
I just want to keep touching on this. So holidays, expenditures, if it's an asset that can be sold, if they spend it on an asset, then obviously that gets included in the property pool.
No, not always.
Okay.
Sometimes. So a classic is that someone will go out and buy a $70,000 car or a $50,000 brand new car. They drive it off the lot. It's worth less, right?
Mm.
And they'll say, oh, well, the car's only valued at $40,000 now, so that's all I've got. No, you had $70,000. You chose to blow it on something that's going to depreciate, and we'll keep that $70,000 in. And that's a vigorous argument I always make, that it's a bit like the Bali holidays.
Yeah.
Even though he's still got the asset, let's not value the asset. Let's just keep that money that he had front of mind. And, the car is what he's done with his share.
Okay.
And that way he or she, they get to wear the whole weight of the depreciation of a vehicle.
Right. So really, when it comes down to it, money that's already there from the separation date needs to be treated like it's part of the property pool, whether you spend it or not. But the catch is, and I do worry for our listeners, because I know a lot of people are going to mediation. I know heaps of them are not going to court. And I do worry that they go into mediation, their focus is fully on the children. And they just want it sorted. They want it all done. And the property just kind of coasts past. And they miss all these opportunities to gain some of those add backs, to say, well, you went on holiday to Bali, so that should be added back. Or you paid for your girlfriend's new diamond
bracelet.
That money should be added back. How do people get the energy and the determination with their lawyer, if they've got one or without, to ask the mediator to include this, to ask the lawyers to include this? Because I know when people are going through divorce and mediation, they're triaging what's the most important thing to them. Yeah. And if you've got kids, it's going to be number one on your list is the kids. Yeah. And then the next thing's going to be the house and stuff. The last thing you're thinking about is these add backs. So how can you recommend people get the know-how and the power to be able to make sure that doesn't get missed out?
Yeah, I think it's important to just start saying it. Just put it in every spreadsheet you do. Put it in the documents you do. Put it in at the amount that was taken, not the products that have been bought with it. and just be firm about it so that every discussion, you've got that written in there and you can raise it. Now, people, like you say, they're wanting to settle the children's matters, they're triaging their lives. It may be that you are just too exhausted and couldn't be bothered arguing over $10,000 or $20,000. You know how difficult it'll be if you raise it, and you might have to go to trial, and it's probably the only thing stopping settlement and all of those things. So sometimes people just make a rational decision to let that go, and that's fine. But otherwise, just keep documenting it. That seems to me to be the best way to make sure you don't forget it. But you can use these ad backs as two ways. Like, you can use them as a shield. So if there's any allegations to you about you wasting money or what you've done or any little petty thing they've given to a relative years ago, you say, yes, but you've had these ad backs, you've had these drawdowns, and I'm not going after you for those. So don't you start nitpicking with me, or I'll be raising those again. So it's kind of a shield, right? As well as a sword, to say, if you've got a reasonably small property pool, like 100,000, right, and each of you took 40,000, so there's only 20,000 left in the tin, hypothetically here, and they've blown theirs, you can't afford to let that go. You're going to have to keep arguing. And I hope, Rosie, what we're doing, hopefully, is helping people to know these things and keep an eye. It's terribly frustrating, though. It's hard. It's hard to watch.
So let's get into wages and income. So you've separated, and we get a lot of questions about this as well, and some horrible questions that break my heart, where people are still giving their wages to their ex, and their ex is still controlling, and that's obviously financial control. But what should or what can people do? Obviously get legal advice and financial advice. But once you've got that separation date, once you are separated, what happens, and how is the income from your job looked at?
It's yours. It's yours. You should, I think we always recommend, and I've done this all my working life, is recommended my clients to go and get another bank account, get their wages into there. And look, you will still have joint obligations, right, with the divorce or separation, especially in the early days. And you can then put money in if you want to for mortgage and put money in for other stuff, but start as you mean to go on, set up your own account, direct your wages into there, and that just starts to give you a feeling of self-determination and managing by yourself. Plus, you may need to show your wages if you're going to get a loan or rent a house. So your own bank account, preferably in another bank. I can see that look on your face. What do you think?
We always tell our members to do that. Start as you mean to go on, get your own bank account, put your wages in that. If you're afraid that's going to cause drama, then maybe ring 1-800-RESPECT and just see what kind of relationship you might actually be in. Because if you're separating, you should be entitled to take your own pay and put it in your own account. And if you've got an amicable relationship and you trust them, you should be able to share the bills, etc., and put money back into another account. But you want to have control over your own money. So you're saying, Mum, that your wages, the money you earn, that's yours. That's not looked at. But
I see this look on your face.
People make their money, right?
Yes.
Lots of people just have two bank accounts, if they're lucky. One for bills and one for income.
Yeah.
How do you pull apart the difference between what they've earned and what they're spending their money on, and like matrimonial money? Because people probably have a big bank account with lots of money in it. Well, hopefully for some people. I know I don't.
Look, the thing is, if your wages get spent, then there's no asset left at the end of the relationship that can be attributed to you. In other words, you're not saving your money. It doesn't get put into the tin. If you spend it all, it doesn't get put into the tin. It's not an add back. You're entitled to live on your wages, right?
But if you save it, it gets put back in.
That's right, because it's deemed to be kind of surplus to your needs. And you know, and I know, and our listeners know how hard it is to save up, especially if you've got kids and you're trying to keep the car on the road, and the rent or mortgage these days phenomenal. But yes, so the court, first of all, has to decide if it's worth if it's just inequitable to divide the property at all or just leave it like it is. But their next step is to gather together all of the values of everything, okay? And if your wages got spent, then there's no asset there. If, however, you didn't contribute to something that you should have been contributing to, then you may be penalised for that in a percentage reduction.
All right, and that's what we get into next. And we have a great episode on mortgage, who pays the mortgage, and I'll put a link in the show notes for that. But this one really comes down to, there's obviously going to be bills between separation and property settlement for the house, electricity, real estate fees, rates, all of that stuff still got to keep going. They don't put a hold on it. I wish they did. I wish they went, oh, you're separating? We'll just put a hold on everything till you settles. That would be great. If anyone's listening who's in Parliament, create that. That'd be fantastic. But basically, you've got to keep the wheels going.
Yes.
And there are some people who write into us where their exes are jerks or they're incapable of being able to pay it, and they're having to pay for everything. How does that get looked at?
It depends. If it's a house that you're living in and you're paying for everything, the court won't go adding those payments back or anything like that. They expect you to support yourself and pay the utilities like phone and electricity and stuff for the property that you're in. So you don't get any credit for that. So there's no consequences if the other person isn't contributing. If, however, you might have paid something off, like you might have paid the car off post-separation, after separation, then that contribution is measured for you in percentage contribution of some sort, because the car, imagining our car, and it was 75,000 and you've paid off 40,000 of it. Well, then you've increased the pool by 40,000, 20,000 by you, and you've also paid 20,000 that should have come from the other person. So that might get added back. So it's all those wheels and cogs, Laura, that need to go around. And I hear you when you say it'd be lovely if the banks and everyone would stop because of separation. And some of the banks do have programs for people who are genuinely separated. But of course, it could be rorted. I'm sorry to think like that, but time anyone had problems with their mortgage or wanted to do something else with the mortgage, we're separated. Can we have a 6-month break? So that's probably why they haven't done it automatically. But they are very caring, the people in those areas.
I feel like when it comes to expenses, when it comes to your income, when it comes to the matrimonial savings that you would have had before separation, if you are not super diligent and super organized with documentation of who spent what, when, where, how, you are going to find it hard to argue for all of these add backs or using add backs as a shield or trying to get, a fair go of this bit in between. And particularly for those people who they get separated and they just leave it for ages.
Yeah.
And then I see these people, they panic because they've noticed their ex is hiding money, buying properties, or things are getting sold for not what much they're worth. And they're seeing all this money shuffling going on. And then they realize, I really need to get this property settlement happening.
Yes.
And by then, when they sit down at mediation, and it's been going on for 2 years, they've got no idea where the money's gone. They've got no documentation of what's been spent on what. And it's quite a big mess. And I can see why people just throw their hands up in the air and go, whatever, let's just deal with what we've got. Yeah. And I think that is a strategy of the manipulative and controlling type.
Absolutely.
To just confuse the whole system, to just throw everything and make you forget to ask for that add back.
And they will carry people along. We hear it all the time, Laura, don't we? Who thought it was going to be okay and we were going to be amicable, and I didn't want to rush things, didn't want to make it bad. He asked for some time. She didn't want to do things for a while. And all the time, they've just been dangling their ex on a string while they are quickly making arrangements to suit themselves. And it is very hard to unpick. But here's a little word of maybe comfort or encouragement to someone.
Need to start doing your disclosure but have no idea where to start? Feeling overwhelmed about mediation coming up? Or just trying to deal with negotiating with a manipulative ex? then you need to go to thedivorcecourse.com.au to go to the free resources section where you can get a mediation checklist. All you need to do is go to thedivorcecourse.com.au and go to the free resource section and download the free checklists today.
And all the time, they've just been dangling their ex on a string while they are quickly making arrangements to suit themselves. And it is very hard to unpick. But here's a little word of maybe comfort, maybe, or encouragement to someone. You'll never really know what a person's doing with the money in their lives, because that case of Gollings and Scott said people aren't expected to go into suspended animation. They've got to be able to use their money. But if there's money come out of a property pool or a bank account or the mortgage offset, that's what happens a lot. You know it went out. You can see it went out and it went into an account of his, and then you don't know what happened to it after that. That's fine. You just have to show that it went out of an account to another person, and that person has to explain what they did. And if they don't, the whole dollar amount, the whole of the money that went over should be added back in. I think the reason add backs don't get as good a run as they used to, as perhaps they should, is for a couple of reasons. One is it's complicated, expensive, and you're not sure if you'll win if you go to court. The second thing is I don't think enough of us are asking the judges to make findings about add backs. I think that because it's a bit hard, people are just letting it go.
So one of the strategies that you could use to avoid this situation is be proactive and get your property settlement sorted sooner rather than later.
Yep.
And I know that's so hard because a lot of people write in, and I remember the last thing I wanted to deal with was figures and numbers, and
Yes.
I just needed a break. I needed just to disconnect from it all and stick my head in the sand. Obviously, I probably was an avoidant type, but you know, a lot of people don't want to deal with it. But it seems to me, I know you always describe it as a big ball of yarn and they're slowly unpicking each bit to figure out each part of the divorce separation. But the longer you leave it, the bigger the ball of yarn gets. And I guess you've got to kind of be in your head saying, I know I need a break. I know I need some mental health time, but am I aware that the longer I leave it, the harder it's going to be? And if you've got a manipulative, controlling type or a high conflict type, the harder the argument is to get a fair amount. And there are playbook after playbook that these people follow, and it's always the same. It's drain the bank accounts, go on holidays, spend everything,
and then accuse the other person of doing it.
Yeah, and just
then accuse.
Yeah, and using the Darvo method. You can go and listen to that episode, Ways to Protect Yourself from the Darvo Method, which is a narcissistic strategy. Go listen to that episode. I'll put it in the show notes. But Mum, do you feel that would be a good strategy to avoid all of this?
It is, but people can only do what people can do.
Yeah.
And you're processing, you've got children. I'm never critical of people who are misled, perhaps by their ex. The only thing I would say, if you are not in the headspace that you can start this sort of detailed tracking of things, if nothing else, can you take a screenshot of your bank balance on a certain day? Can you print them out? Can you even video the ones? I mean, a lot of us don't get hard copy bank accounts anymore, bank statements anymore. But if there's a joint account, you may lose access to that if they do anything funny. So screenshot it, keep those photos so that one day, if you have to, you can show the judge or show the lawyer at mediation, the other person, what happened to this 50,000? You know, what happened to this money? He's had it, she's had it. It's part of their property pool.
And I think it's really important what you've said before is the onus is on them to prove what's happened to it.
Yes.
All you've got to do is show it's missing. And
That's
so
right.
the way you show it's missing is by having a screenshot of when it was there and a screenshot of when it's not there. That will save you. So there are lots of proactive things you can do.
Yeah.
You can also learn about the process. And I know a lot of people get so overwhelmed by it. That's why they don't do it. They don't know any of this. I didn't know any of this. So I was like, I don't want to deal with it. So if you learn and educate yourself and you're aware of what could happen, you're probably more likely to be a bit more proactive and get things rolling. We forgot to mention Services Australia. We get this question a lot. So some people save up Services Australia money, their pensions and things after, because again, a lot of people are in the mindset of I'm free, I'm an independent human, and I'm going to save and be responsible and start my new life, even though they haven't had property settlement. What happens to money that you're given to by the government?
Nothing different. It's not different. If you saved it up, the court's view, I think, is that if you were able to save your Centrelink money, you were using some other sort of money to eat and sleep, put clothes on your back and a roof over your head. So it is, calling it Centrelink money is just convenient if you're just going to make it go into a savings account. But in reality, it was meant for you, Julie Ron. You've been using something else. If you had lived on the Centrelink stuff, you'd have put the other cash in the account. Does that make sense?
Yeah.
So it's not separate. It's not a different character.
Okay.
And frankly, it's such a low amount of money. I take my hat off to anyone who can
I know we
save
had
on it.
a lady write in and she'd saved up all her money for Centrelink by not, I don't know, all these things she listed that she'd given up. And then her ex had said that needs to be included in the property pool and she was devastated. But
Oh.
yeah.
If that happens to anyone that's listening here, think about this strategy. Say there are two pools here, two pools of property. One is the stuff we had when we separated, and that's fine, it carries on to now. But I say that this money that I saved up is a separate property pool. It's a post-separation property pool, and I made 100% of the contributions to this money. I should be allowed to keep it.
Okay.
Then it just is a financial resource in your head. But the two-pool approach is surprisingly not used as much as it should be.
Mm-hmm.
But Norbis, very old case, says that the court can look at it any way they want. So post-separation, I think this is the dawning of the age of a distinction between during the relationship and post-separation. I think we're all going, that's my feeling. I've only seen one or two cases, but I'm starting to see, I think, a trend developing where what happens after separation is the sphere at each individual and not as blended in with everything during marriage, particularly if the separation's been a long time.
Mm.
I mean, some people put a lot of extra money in their super post-separation.
What do they do about that?
Well, what the court will do is usually they'll say, this is the amount of superannuation, this is the amount of property, and your so contributions before, during and after the relationship, cash, non-cash, whatever. So post-separation, I've put an extra $8,000 into my superannuation or $80,000 into my superannuation. And it shouldn't be that I did that out of my wages and they shouldn't have it.
Okay.
But if the court doesn't put it in as a separate pool, then what they will do is give the person who put all that extra money aside or banked that money a higher percentage of the overall property pool.
Okay.
It's not a dollar for dollar swap.
So when it comes to expenses, if they're reasonable living expenses, then they just go away. Can you just give me a rundown of what reasonable living expenses are?
So judges have to think about this all of the time. I can tell you what aren't. Gambling and prostitutes is not reasonable expenses.
Okay.
Well, I'm saying it like it is.
Okay.
And cosmetic enhancements are not reasonable expenditure. However, medicine, food, housing, clothing, physio, chemist, school fees, sports, hobbies, as long as it's not too over the top, they are all reasonable living expenses.
Okay.
And so if you're going to be dabbling in any joint money for any purpose, if you can think to do it, just document it, what you're spending, and find the easiest way that works for you. If you're all distressed, which may be, find something really easy, even if it's just take a screenshot, shove it in a folder on your phone marked Y for yucky, and you can have a look at it later on.
Yeah. And I guess the way that you can keep an eye on what they're spending, because I think some people are in situations where there is joint property money, there's always been a big lump sum of something, and that money's sitting there. They can't take it out, they can't access it, but they're watching it go down. It's through disclosure, I guess, where you see the bank accounts and then you go through them. Is that how you do that?
I guess so. But if there's two of you got a joint bank account and you're not taking any money out and the money is going down, I think the other person has some questions to answer about it, So a disclosure may show you, it may not. But again, I think if you can show that it's plummeted in value or plummeted in numbers and you didn't do it, it's a very small step for you to prove the other person's done it. And then the onus is on them to say that they weren't just siphoning it off and hiding it under the bed or something. I have to prove it.
So just be aware, everyone, that once you have that separation date, once it's done, once you've separated, you've got to treat everything with care and document, record keep, and be aware that you might have to go into fight if it's worth it to get some of those add backs or to make sure that you end up getting what's fair. Because the tactics do seem to be to run it down and say, oh no, all that money's gone. I spent it all.
Yeah.
And sadly, so many people just go, oh. And the other side of that is if there is nothing else to add, if they run all the assets down and there are no other assets, there's no such thing as an add back if there's nothing to add back. So is that does happen to people, doesn't it?
Kind of. I guess it's a notional add back, right? So add backs aren't really dollars put back into the account literally, but it's an imaginary put back.
But if there's no money left in the asset pool, if the person says, I've got no money and there's no money left in the asset pool, putting an add back with them with no money, how does that work?
You wouldn't be going to court probably with no money. What you can do though, and I've seen people put everything in the name of a relative or in a trust, and then what you do is you go to court and ask for a Section 78A declaration. And the declaration is that money that my ex has put over there with their brother-in-law is actually our money, and the court can look at that and make a declaration.
Right.
I'm fond of saying, and I've been saying it for 35 odd years now, and I believe it with all my heart, people can't think of anything to try that hasn't been tried before. I think every scenario pretty well it has been done before, and these people think they're an original, but they're just doing what everybody else has done.
Okay.
No.
Now, we've talked about debt before, and we're not going to touch on that today, but we've got an episode on debt that you can go and listen to. I'll put the links in the show notes for that. So what happens with debt after separation? Do you end up with their debt? All of that is answered in that one. So today we're just doing an overall view of expenses, income and savings for you between settlement and separation, because I think a lot of people, they get separated and then they're looking at the end goal. And then all this distraction and all this cheeky nonsense happens when you're not paying attention. So if anything from today's episode is pay attention, be mindful, record keep, and definitely keep your finger on the pulse. Is that right, Ma?
I agree. Absolutely, Laura. Absolutely. If you can, with great love, and only if you can do so safely. Because sometimes that's an impossible ask for someone going through their stuff. But yes, be mindful and set up a rudimentary system so you can at least keep a track of it when you feel you can look at it after. And here's a tip. Think about how that person you were with, your ex-partner, how was that person with other people? How was that person with work, with business associates, how was that person? And if that person was pretty unscrupulous or a person who plotted and planned, then you have become no more important than a colleague or a business associate, and you can expect that same behaviour again. So just be wary, Laura. Hey, be wary if someone's stringing you along. And a number of people who feel trapped, and it's a trap designed well in advance
by poopy pantsers. And I swear they tell each other about it and they share their little tips. So we're sharing with you what you need to be proactive. So we're on to you, people. But anyway, thank you, Mum, for today. Hope that answers some questions that might be running through your head or wakes you up to some things that maybe you haven't been watching or paying attention to.
And go and see a lawyer. Get your advice, because every situation is different and we don't know your exact situation, and it might be that you have an exception to these things. Like it might be different for you, but go and see a lawyer. If you've got a lawyer and they seem to be not getting involved with ad backs, ask them why they're not doing ad backs, and ask them, can they give you that advice in writing, and just make them think about it. because sometimes I think in the profession we get busy, court day after court day after court day, and I'm in the luxury position of being able to read cases, and I love that. I can keep up to date. But sometimes I think people get so busy they don't get to read the latest cases. So it's good for you to know a little bit and just check on how things are going with your lawyer.
And if anyone's interested in that, we're episode, we're a Weir case, you can go listen to that on our Patreon account. All right. Thank you so much for your time, Mum. Good luck.
No worries.
Putting things out there. And
all the best.
We'll be back next week. Bye.
Okay. Bye.
If you found this podcast helpful, we'd love it if you could rate, review, and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only, and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording.